The August term of the Court of Criminal Appeals in East Tennessee. Joining me on the panel today to my right is Judge Camille McMullen, our presiding judge of the court, and she is from Shelby County. And to my left, Judge Jill Barty Ayers. She is from Davidson County. I am Kerwood Witt. I am from Monroe County. Arguments are 20 minutes per side. If the appellant wishes to reserve a portion of that time for rebuttal, then counsel needs to make a statement to that effect at the beginning of the opening argument and inform me how much time you want to reserve. I don't believe we have any preliminary matters.
Yeah, Your Honor.
Would you call the first case, please?
Paul Jerome Johnson Jr. versus State of Tennessee.
Good morning.
Good morning.
I'm Attorney Terrell Tootin on behalf of the appellant and defendant, Paul Jerome Johnson. I would request 4 minutes rebuttal. This matter, as I spelled out in the brief, I went very extensively in the brief. I just want to highlight a few points here. But this matter basically revolves around two main issues that we're raising. One is that the appellant did not receive the appropriate level of due process under the law. And then two, he received ineffective counsel. I'm not sure if any of the allegations that was raised in the brief is actually allegations that opposing counsel has attacked or discredited, as much as there's arguments about whether or not they're properly before the court or waived. And so that's what I'll get into. But first, dealing with the due process issue, that focuses primarily on the trial court judge in this matter. As I cited in the brief, I cited to a case that makes it clear about how it's very important that a judge has to be careful to give any impression of any feelings or statements or anything that could potentially sway the jurors. Well, in this case, and again, I don't believe it's even challenged by anyone, the appellant's family in court were forced to sit behind a section in which they were caution taped off. The only ones in the courtroom in that environment, in that setting. To this day, there's no justifiable or reasonable explanation as to why they would be put in that setting or roped off in such a manner, but there can be no question that that can influence or impact the jurors, how they see the appellant or his family. Because if you're portraying them in a light that makes them appear to be violent or aggressive or confrontational or needs to be segregated from others, it's hard for that not to give some impression to the jurors. But
these due process issues you're raising now, are you not raising them for the first time on appeal?
Yes, a lot of this, and I guess that's the problem that we have. When you're dealing with a post-conviction, the issue is to say that one of the ways you attack it is either due process or ineffective counsel, and the position is due to these defects or due to these issues, then the appellant or the defendant never actually received a fair trial, never actually received the right to counsel. So the concern we have is the fact that these issues weren't raised and were blatantly obvious and should have been raised. That's what we contend this post-conviction proceedings is for, to correct those issues, to say these issues is to show why counsel and the trial court and everything, why this happened in such an inappropriate light. Is to say that these things should have been raised. These things should have been argued. The appellant can't get up and do it himself. He's represented by counsel.
Mr. Tootin,
yes.
So we understand how to handle or develop a post-conviction case. What I don't understand from your filings is you don't attack trial counsel's failure to do any of these things or appellate counsel's failure. You make a standalone due process claim, and that is a problem in the post-conviction context. So normally what we see is, if someone's trying to make that claim in the post-conviction context, they're going to attack trial counsel or trial counsel's failure to do those things. So what you're doing here is you're attacking the trial court. And the reason that's waived, as stated by the post-conviction court, is because none of this was raised below. And that's just what our law requires.
So to go to that, there's layers to that. So one is our position is there was questions in the post-conviction transcript about why these issues weren't presented or that they should have been presented by trial counsel. So specifically, one of the key and material issues we raise here is that apparently the trial judge had a conversation with the grandfather of the victims in this case, and he made it known the first time he had that interaction because he realized by speaking to this person, I believe that was on March 13th of 2013, he realized that that's something that should have been disclosed and should not have happened.
Well,
Yes.
Judge McMullen and Judge Ayers are asking you about issues that were not raised in the post-conviction proceeding.
So these issues were raised in the post-conviction proceedings. So maybe there's a confusion there. Everything I'm saying you'll find supported in the transcript. In fact, we have exhibits that also go to these arguments. So they absolutely were raised.
Will we find those things expressed in your brief?
Yes. That's what I'm saying. Not only is it in the brief, but it's in the transcript as well. In fact, I believe it was volume 6 that has a list of multiple exhibits that goes directly to this issue. Because as I was saying, as it relates to the judge on March 13th of 2013, he made that known. But then on March 15th, apparently he had another conversation with the same individual, and he did not put that on the record, did not disclose it. According to the post-conviction proceedings, the trial counsel asserts that he was not aware of the second conversation. The state attorney alleged they weren't aware. And then we have exhibits which are not only photos, but then their witness testified who was able to pull the timestamps up to verify that the dates and times this happened. So our position is, and I understand and appreciate the question, but we believe that this is appropriate before the post-conviction court because as a minimum, the judge would be what we would argue is a state actor, and this would be evidence and information that was relevant and that the defendant or the appellant was entitled to. And what I understand the case law to say, of course...
Let's get back to our issue, because you're kind of merging lots of different arguments. Waiver issue. You're going to the trial court's bias, and you're getting into the facts of that issue, and without addressing the waiver question.
So, and I guess my answer to that is, and what I was attempting to do is explain the reason it's not waived is because when you have a state actor, which would be the trial court, and this is evidence that is relevant and vital to the defendant is entitled to it. And so when the defendant doesn't get that evidence that we would say is either exculpatory or Brady, when there are Brady violations, the case law says the way to attack that is through the post-conviction court. So it's our position.
That's not what it says.
Well, I have.
That's not where you cited Nunley. That's just not. That's just incorrect law.
Well, I want to be, and again, if I'm incorrect, I'm sure the ruling will reflect that, but I want to be clear what my argument is, that when you have Brady violations, and I've cited to it in the brief, and I don't believe the law has been overturned, but what we would typically...
I'm not sure what your Brady violation is.
So,
yeah, that was going to be my question. What are you claiming as a Brady violation?
To the extent that this information regarding the judge, our position is the judge is a state actor. That state information, that evidence and information should have been turned over. It should have been disclosed to the appellant or the defendant in this case that there was this interaction that happened outside of the defendant's presence with a judge, with someone who the judge, quite frankly, should not have been speaking with. And so that's where we allege that information should have been provided or given to the defendant. That is what we're alleging is Brady, and we're alleging that when there's a Brady violation, that a post-conviction court is the proper place to handle it. So again, we might, I don't know what part we disagree on, but I at least want to be clear on what I'm saying. So if you disagree, at least you know exactly what I'm arguing when you disagree. But that's where we get, that's how we say that that's a Brady violation. We believe, so to put it another way, that the appellant had a right to know, a constitutional right to know, that the trial court judge was interacting ex parte with a family member of the victim and did not disclose it to him, even though the first interaction was disclosed. That is our contention. If that is considered not an issue or not a violation, I'll be clear, we lose on that argument. But
Is there any case law that supports that position?
Well, that's why I talked about earlier about a judge having having appearance of impropriety, being neutral and objective, and the defendant having a right to a fair trial. We believe that all supports the fact that a judge can't then secretly go have conversations with a family member of the victim on the case, especially in light of the fact the first conversation that's had, the judge goes out of his way to put it on the record to say, I didn't realize who this person was and that was a mistake, but then tells us nothing about the second interaction that's had with that exact same person. So all the excuses would be gone, and then there's an obligation, even by the judge's own standards, to then disclose that interaction. That's our position. So I mean, I understand if your honors, you make the final decision. If you disagree with that, I just want to make sure I'm articulating the position so that when you disagree with it, you can feel comfortable knowing that you understood what I said and you still disagree with it. As it relates to the ineffective assistance of counsel issue, we raise multiple issues there, and I do very extensive citing to show that these are not issues that were waived for any strategic reason or for some reason that made any sense. They were basically issues not raised because it was ineffective counsel. So the luxury we had in this case is there was already a trial. I'll call it trial one. The trial counsel stated that he reviewed those transcripts and understood them extensively. And so when the mother of this case and the appellant are the only two people charged with this crime, they're charged because the theory is, and even the trial counsel admitted, it had to be one or the other who committed this crime. It's either appellant or it's the mother of the child. No ifs, ands, or buts. So their credibility, how they present to the jurors, what information that the jurors have regarding them is vital and is outcome determinative to the case. The mother in this case was able to testify about all the different children she's had, and she was able to tell the jurors about them, which is not the end of the world isolated, but when you're trying to bolster this mother to make her a more credible, loving mother to the jurors, because you're basically sending the message she could not have possibly done that, only leaving the appellant, that clearly opened the door to talk about all the different concerns, such as her oldest child was taken away from her by DCS as relation to these allegations. Somebody who's completely innocent and done nothing wrong, the argument would have been made, you don't lose your children to DCS on top of that. That's compounding the injury. That should have been raised and brought up, and that was never done. Also, another child had opiates in the system when they were born. When you're talking about your children and where they are and how they're doing now, you've completely opened up the door to that, for that to be walked through. Also, there was testimony by the mother that the children had no health problems. That was not true. The older child had, the child that ultimately was deceased had older injuries, and they were all contributed to his death. That's clearly cited to the transcript. So that door gets open now to talk about, well, when you say there's no health issues, this child had older injuries and they were all a contributing factor to the death. When that information doesn't come out, mother appears like a saint, and you're trying to determine who committed this crime, and there's nothing to suggest mother did it, and so you're left with the appellant by default. A child that appeared to have been whooped regularly. That's a very important thing that didn't come out, that the door got open for that to discuss. Child had injuries from 2 to 30 days old. That's extremely important to discuss when these things are coming out. The mother also said, which I think was vital that never comes up, that the child was listless and lethargic from July 13th and before, but then she only stayed with the appellant from July 17th or 18th or some point in that week. It should have been unconceivable for that not to have come out while she's testifying, so that the jurors can be made aware of these things. It was also clear that the child, she admitted, was spanked, and that she was the one who disciplined her kids. She was the primary caretaker. There's also testimony that the child appeared to have been hit multiple times. A lot of the stuff I'm highlighting came out from trial one, but it was not brought into trial two, even after the mother opened the door for all these things. She also
At the post-conviction hearing, did you put proof on of all of those things?
Yes, we raised it because what we did at the post-conviction hearing, we incorporated the trial transcript from the first one because we were going to be arguing back and forth. And then I asked the trial counsel specific questions. Would this have opened the door? And this is in the brief where he concedes, yes, if this happened, it possibly opened the door. Yes, if that happened, it possibly opened the door. He couldn't remember exactly how it happened and was going to rely on the transcripts. So I cite to the transcripts where all of these things happened. It opened the door, and he did not utilize that at all in a case where we're trying to determine of the two people who was responsible. The other thing that I thought was huge that never got explored at all is that there was testimony by the mother that the child had just eaten pork chops, macaroni, and cheese, but then we have testimony from a doctor that there was no food found in the child whatsoever. So all of this goes directly to the credibility of the mother, what she's saying, and all these doors she's opened. So even if the belief was, well, I'm not able to get into that, or the judge made rulings that I couldn't get into that, all of these doors got opened when these testimony and these conversations happened. There was also testimony that they had by a doctor who said, I think her name is Polchan, Polchan, testified that the child looked well taken care of, and obviously the primary caretaker took good care of them. Well, when you say things like that, you've absolutely then opened the door to say, well, when you say well taken care of, are you discounting the fact that the child was whooped regularly, had pre-existing injuries, all of them contributed to the death, mom's primary caretaker, and it also came out that the appellant didn't discipline the child. Even the mother said that. So these are things that should have all been raised by trial counsel, and trial counsel concedes if these things actually happened, because again he couldn't remember, that yeah, that's possibly these doors were open. So then I take a lot of time in the brief citing to where everything I alleged happened actually did in fact happen in trial. So there can be no argument that these issues were waived or not utilized because of some type of strategy involved. It was clearly not raised or utilized because there was ineffective counsel. So I don't think there's much of a question for that. So, I'm sorry.
I was just going to say you're down to your reserved time.
Okay, and if there's no questions, I will be back shortly. Thank you.
Thank you. General Ball. General Ball, you and I both have sprouted some gray hair since we started doing this work.
That is true, Your Honor. Quite a few of them in my case. I've also had to start wearing reading glasses, which to me is an even worse indignity.
Go ahead.
Good morning, Your Honors. May it please the court, Ben Ball on behalf of the state. To start with, I would like to just trace the claims that were presented below. And to be clear, the defendant's claim about trial court bias was presented as a standalone claim. It was presented in the post-conviction petition. It's not being presented for the first time on appeal, but the post-conviction court did find it to be waived. The defendant also presented a single claim of ineffective assistance of counsel, and this claim concerned cross-examination of the victim's mother about dismissed charges. That was the claim presented. Because other evidence was presented and argument made, the post-conviction court also considered whether counsel was ineffective in cross-examining about the custody arrangements. That's the limit of what post-conviction court considered. So now turning to the standalone claim, as I think that Your Honors have gone over pretty well, this is a claim that had to have been raised previously, and it was not. This is not a Brady claim. It was not presented as a Brady claim. This is presented as a claim of trial court bias for the first time on post-conviction, and the post-conviction court properly found it was waived. If this court looks at the record on this matter, I know there was a lot of discussion about the trial judge holding a baby, things of that nature. That is not undisputed in the record. There is significant testimony to the contrary, but ultimately it doesn't matter because the claim is waived. Turning to the ineffective assistance of counsel claims, as we've covered in our brief, this court is confined to those issues ruled on by the post-conviction court. And here, the issue raised in the brief concerns the custody of the son. And quite the post-conviction court properly found petitioner failed to demonstrate this claim. And it's not clear precisely what this cross-examination would have resulted in, and it's certainly not clear that it would have affected the outcome of the trial. For those reasons, if there are no further questions, we would urge this court to affirm the judgment of the post-conviction court. Thank you, Your Honors.
Rebuttal?
Yes. I always find it interesting when you hear the arguments, well, the court probably found this and probably found that. That means we can clearly conclude that it wasn't articulated that way. But I want to be very clear that these issues were raised in the post-conviction court, but again, no one has to take my word for it. I will walk you through, just really briefly, some of the things I said and where I found them. So for example, I said trial court agreed that if the mother testified about the other children, she may have opened the door to asking those questions about it. That's in volume 3, pages 18, line 18 to page 19, line 10. So there's no question that not only was it raised in the trial court, but even the trial counsel admits that that might have been a concern. Trial counsel also agreed that if the mother testified that the child did not have health issues, it would have probably have opened the door to talk about those past injuries. This is volume 3, page 19, lines 15 to 19. So I'm not making any of this up. Trial counsel also agreed, this is all in the post-conviction hearing, that when Dr., I'm going to call it Wezanowski, testified that there were no signs of abuse to the child, it possibly opened the door to discuss the child's prior injuries. So that's volume 3, pages 27, line 13 to page 28, line 1. I'm not making any of this up. So in addition to that, the question is, and I'll be happy to expound on it, well, what difference would that have made if these were brought up? I want to be clear because I think the answer is obvious, but I want to make sure it is obvious. When you're saying that either the appellant or the mother of this child is the only two people who could have possibly committed this crime and done these injuries, and so the juries have to make a determination of who of the ones did it, it's extremely important to say the child had past injuries that had nothing to do with the appellant when the appellant was never around. Appellant didn't discipline the child. Child was whooped regularly. Child had belt marks and loops on him. That's also in my brief where that's talked about. And that the child was listless and lethargic prior to even being around the appellant at all.
What is your basis to say it had to be one or the other?
Well, for two reasons. One is that even trial counsel in the post-conviction said that that's the facts of the case. That they're saying that while the child was with the appellant and the appellant's mom, the child ended up deceased. He ended up being alive and well to deceased, and that they were the only two with him. So not only was that the state's theory, but even trial counsel admitted the entire case hinged around it was either one or the other.
But we've seen many cases where both two defendants, co-defendants participated. I'm just not understanding why you're saying it had to be one or the other of them.
Again,
I understand that could be a trial strategy, but I'm not sure that's the reality.
Well, what I'm telling you is, and again, I know I'm relying off the transcripts as you are, is that trial counsel himself told us that in the post-conviction, and that's the way the case was presented by the state, and it was not countered in that way by the defense. So for all intents and purposes, I understand your question, but what the jury would have received is that version of information that way, and trial counsel also said that was what the issue was. So it was only presented and approached that way by the state and the defense, so the jury only walked away with that image. I'm with you that there is scenarios where both could happen, but in this case, there was nothing presented that mom would have done anything. All of this evidence I'm telling you, which I'm sure is alarming, it never came out to the jurors. They didn't hear about all these other injuries, past injuries, healing injuries, child lethargic. None of that was presented to these jurors in this case. So I don't know if we're disagreeing. I think that I'm hoping I got a vote. I don't know. But that's what it looks like to me, is that these things should have been fleshed out, because it needs to be spelled out at a minimum that, hey, you can't just assume it's one or the other, but that's what was presented.
Your time has expired. Thank you. Thank you both for your arguments presented today.